it didn't hit rain until about going to school. So out where I am was pretty good right up until I got to all the way here really, but it was going to rain. But if it kept that up, you could get excited.
I didn't start sliding until I came into the parking lot.
Yeah. You're right. The parking lot's an adventure right now.
Yeah.
You might have to click on the three dots.
Oh, yeah, 3 dots.
Click on the three dots.
There you
Okay, I think.
That's what I was trying to do.
And I have,
Okay, well, I did that before and I've
Duke
Yeah.
on Zoom as well.
seen the machine and anything. Okay,
A little bit past 9 if we're ready. Oops. I'm not getting a green light.
You're on second, huh?
Jeez.
No.
It's not amplifying me. Huh,
Hold it off.
magic. Oh, we are on, there we are. Okay. It's a little after 9. And I will call to order the Land Use and Information Committee meeting for January 6, 2026. Notice has been posted in accordance with Wisconsin statute 19.84 open meeting law. At this time on the agenda, it's time for public comments. If anyone is here for anything not already on the agenda.
your mic is.
Yeah.
Yeah, your
We're
mic
like,
is-
well, did it shut off again?
May need to use this.
Tanya's got the touch to make it work, I guess.
Hold it down for, so I think if you're low on batteries, it's not gonna last.
So. Anyone's public comment period, if anyone has any public comments to make. If not, otherwise you're on the agenda
Oh, I'm on
later,
the agenda.
so you don't need to. No. Okay. So I entertain a motion to approve the agenda order,
Motion approved. I'll second.
to approve by Supervisor Chuck Anderson, seconded by Supervisor Morgan. Motion carried. Sorry, all in favor? Aye. Motion carried. Minutes of the December 2nd, 2025 meeting.
Motion to approve the minutes.
Motion by Supervisor Blomberg to approve the minutes. You have a question,
Second.
second Supervisor Szymanski.
I do have one really minor notation on page 3. The very top paragraph,
Okay, then.
Don Hamilton.
Top of
Did you find it?
page 3, top page.
First paragraph.
Okay, but
Okay, if you go from the very bottom, it's starting 3 lines up. Mr. Hamilton is in favor or allowing, or should be of, in favor of allowing the current resident. It's very minor, but I just wanted to have that corrected for the record.
sure. Any discussion of the amendment? If not, the motion to approve the minutes as amended,
So move.
by Chuck, seconded by Supervisor Samansky. Any further discussion? Hearing none, all in favor, aye.
Aye.
Motion's carried. Under the public hearing, Jason, you want to
Yep.
carry on?
I have two separate ones to read since it was two separate notices, so. Notice of public hearing, State of Wisconsin, County of Burnett, Tuesday, January 2026 at 9 AM at the Burnett County Government Center, Room 165, Town of Mina, Cyber, Wisconsin, regarding the following Burnett County Land Use Shoreline Protection Code of Ordinances. Number one, map amendment, MAP 2601 Hawkinson, to rezone the parcels with tax IDs 33727 and 33728 with address 1973 Boyd Lane being lots 1 and 2 of CSM number 4503, volume 24, page 312, being the northwest quarter, the northeast quarter, section 34, town 37 north, range 14 west, located in the town of Roosevelt from RR1 residential recreation to RR3 residential recreation zoning district. Zoning change requested by Craig Hawkinson. Number two, a map amendment, MAP 2602 Hardy, to rezone the parcel with tax ID 37056 with address 8085 State Road 77, lot 22 of CSM number 5437, volume 31, page 87, and a portion of the parcel with tax ID 37057, being a portion of lot 23 of CSM number 5437, being both located in the northeast quarter, the northwest quarter, and the northwest quarter, the northeast quarter, section 29, town 41 north, range 16 west, located in the town of Swiss from C1 commercial and RR3 residential recreation to all C1 commercial zoning district. Zoning change requested by John Hardy. And then my next one. Conditional use permit CUP 2519 Yellow Lake Mobile Home Park or Manufactured Home Park LLC. Public notice hereby given to all persons in the town of Oakland, Burnett County, Wisconsin, to Andrew Freeman on behalf of Yellow Lake Manufactured Home Park LLC has made an application for a conditional use permit for the terms of the Burnett County Land Use and Shoreline Protection Code of Ordinances to modify CUP 2119 to remove condition number 7, which stated the expanded site was to be the owner's residence, not rental property. Located on the parcel with tax ID 36493, the specific expanded site has an address of 28271 Ivy Wood Drive in the RR3 zoning district, lot 1, CSM volume 30, page 43, section 20, town 40 north, range 16 west. This item will be after the other public hearings already scheduled, so that'll be the third one.
Okay, so proceed with rezoning request map 2601 Hawkinson. So is the applicant online to talk to us about this?
I'm here. It's
You
great.
are, good. Okay, well, generally, you're just wishing to go from RR1 to RR3. And I think I saw somewhere here the town is supporting these changes more extensively than just your own.
Well, I don't think we got anything official from.
Not
the
official, no,
township,
but
but they're trying to rezone land out of RR1 to districts that have larger lot sizes.
right,
Yeah.
so this is consistent with the town's wishes.
Yes.
So anything you want to add to that? Greg?
No, that sums it up.
Okay, with that, this is a pretty easily a non-controversial kind of request. Committee have any further discussions or anything to add? Well, I think that's sort of so somebody has to talk about it a little bit. So I think it's kind of consistent with what we see the towns generally supporting larger lot sizes with people having more opportunity to do more things on those certain districts. So pretty consistent with what we've seen as public desire on this kind of thing. So if there's anything further, I entertain a motion.
We would need to open. a
Yeah,
hearing.
but public
Sorry.
hearing, getting jumpy.
Yeah, I'm hurrying too much here. Is anyone here, I'll now open the public hearing and ask if there's anyone here to testify on this matter. And seeing none, I will close the public hearing. Pass this to the committee and entertain a motion.
I make a motion to approve MAP 2601 rezone from RR1 to RR3 with the one condition of follow all local, county, state, and federal requirements for this activity.
And I'd like to second the motion.
Motion by Supervisor Locke Anderson, seconded by Supervisor Blomberg.
And that motion is to push it on to county board.
Sorry.
Right.
To recommend approval of the county board, right, exactly. So, any further discussion? Hearing none, roll call vote. Supervisor Tucker,
Yes.
Supervisor Moore,
Yes.
Supervisor Szymanski,
Yes.
Supervisor Blomberg,
Yes.
Supervisor Chuck Anderson,
Yes.
Supervisor Aaron Lockwa Anderson,
Yes.
Supervisor Connery, yes, motion's carried. Recommend approval of the rezoning to county board.
So Craig, that'll go to county board in a couple weeks. You don't have to be there. I'll go there on your behalf, and then I'm assuming they will approve it, then I'll send you a letter telling you their decision.
All right, well, I appreciate that. Thank you very much, everybody.
It doesn't get any easier than this. Next rezone is map request 2602 for Hardy, which is a rezone from commercial and RR3 to all commercial in the town of Swiss. Are you here? Yep. Mark, are you representing him?
Mark Crozier for John Hardy. John's here in the audience too, but I can probably better explain what's happened on this one. There were 3 parcels up there. And we were in the process of, we redivided it, reconfigured it. So he could keep some more of the backland with his pole shed in the back where his septics are and so forth in the open field. And so we reconfigured the lots to have a 5-acre tract, and then the parcel we have here. There's a little bit of, I won't say there's confusion on your mapping and the application that brought in, because we were updating the maps during the process of submitting the applications, and the parcel mapping and so forth hasn't caught up to where the lots were created. And when we were there for the first time for the approval of the town of Swiss, Brent Pardon, Supervisor Eswell, isn't that other part rezone residential? And we realized it was. And so at that time, we started that discussion with them. They were fine with it all being commercial because it shouldn't be 2 different districts in the same lot. And so when we reconfigured the lots, we're trying to make it all commercial, so it's all the same, so that the compliances and the land use will be consistent out there. And the town of Swiss approved it too. We went back to them in a follow meeting with the updates too. So if there's any questions, and Mr. Hardy is here if there's any other questions on there. He does sell things out at the highway there too. So he does run some commercial activities out of there too. So we want to make sure it's all compliant. So
Right, and he did have a partly commercial lot already
yes,
on that.
yeah,
That was the one thing that caught my attention, only with the town's plan doesn't really reflect that. But, and if this wasn't already commercial, I think that would be something to talk about. But because it already is, I'm sort of an outlier to the plan, but it wasn't addressed by the town. Might be something they might want to do next time, but.
it was a commercial business there many years ago, and he's always sold some things, and done some things there too. All along, so.
And you understand, just because of it, we always check for consistency with the plan.
Yeah.
But I can kind of see this is already inconsistent and was known to be, so to speak. And it doesn't change the reality on the ground at all. Anybody else? Nothing more to add, so I'll open the public hearing on that. If anybody else has any wishes to testify anything on this matter at all? Go ahead, come forward and identify yourself.
First of all, good morning.
My name is Roger Nealon and I just recently purchased a lot out on Highway 77, okay? My wife and I have, in the process of the last 5 years, we're trying to get to that point where we wanted someplace where we could retire, move out of the city, which is where I'm from, and find something that was ours, okay? In the process of doing this, we started looking at everywhere, Siren, Grantsburg, Spooner, even as far as, Danbury. Eventually it came to a point where we were looking for an existing home and we couldn't find anything that we were comfortable with. And I finally decided to talk my wife into, let's build what we want. So then we started looking for land. Once we started looking for land, we incorporated and got a hold of Jeff Howell out of Siren to be our builder, okay? I also talked to the realtor and I told her exactly what we wanted. After discussing it with her, we found this lot on Highway 77. It was residential. And I made sure that I asked her that. I said, is this residential? She said, yes. Okay. In the process, we purchased the land. We started doing everything we need to do with permits and everything for building a house. Okay. Everything was set in stone and pretty much our timeline was to start in the spring. And then suddenly here in November, I get a letter saying that somebody wants to rezone it. Okay. I don't have a problem with people wanting to aspire to do their own thing and be a commercial, but when I build my retirement home, I don't want to sit in my backyard looking at the sunset and all of a sudden I hear a forklift beeping, backing up a half mile down the road that's unloading these large containers that, I don't know if you've ever heard them, but they do make a lot of noise. And when I looked up the website for the county, all it said was that there was going to be trucks and containers. It didn't specify how many, didn't specify what kind of operating hours they were going to have. It just said trucks and containers. It could be 20, could be 200. I don't know. But it's something that I don't want to listen to if I'm sitting in my backyard and enjoying the sunset. Thank you.
Any further just public hearing comments? I have a question for you, if you don't mind. Come back. I should have stopped you from going, but
No, that's okay.
how far away are you from this particular site?
There's one 5-acre lot in between me and him.
Okay, just one pertinent to the
Right. And then
discussion.
where we're building our house, we cannot see anything. We can't see a neighbor. We can't see his lot. It's mostly wooded, but the sound.
The thing and that's an already existing activity, but anything you would do that would, I shouldn't say not anything, but some uses are permitted in commercial, others are conditional uses where there are hours of operation and whatnot. And I guess all I can say is that should something come up on that, you would be within the range of notice of any activity that would entail that kind of thing. As I noticed.
I did notice when we was looking at the property that he did have containers out by the road and I kind of thought, okay, he's got them there. Maybe he's selling them to people that want them, but I didn't know the entire scope of the business, how large he wanted to get. And that's the reason I came here, because I'm concerned about how large it could get and how much noise it could create.
All I can say without a specific issue to address, it's hard to say that what it would be. But many things that are more disturbing by permitting that deal with those kind of issues. Just for some comfort for yourself. It isn't like commercial that anything goes. Some things are permitted, some things are conditional use, which puts a public hearing process onto the activity.
Right.
Just so you kind of know. That's all.
Personally, I've never met Mr. Hardy, but I would like to get with him after this is over with to discuss it and find out what his plans
But
are.
at this point, the site is as it is now, and you bought as it is, but a major expansion would probably trigger something that you would be involved with. That's the best I can tell. Okay? Okay. Pardon? Oh, okay. Yeah, just a minute to get some clarity on that. So no one else is here to speak, so at this point, I'll close the public hearing and open it to the committee.
So in order for him to, I mean, it should be zoned commercial, but in order for him to put a specific deal in there, he'd need a, you know,
No, I'm just saying it depends. He didn't propose any specific activity.
Right now, how he's operating would allow, that use is allowed in commercial.
The permitted use that he has, but I think that the neighbor or the nearby neighbor is concerned about what else could happen. And I just wanted to make it clear that any big, loud activities then would require conditional use permits. But many things are permitted and you can do those. You know, some of them will require permits and some are already just generally permitted, but.
So without going through the whole list, I mean, right now, when it's commercial, you could have a retail store, professional office, banks, laundromat, restaurants, tavern, medical clinics, auto service, motels, tourist homes. So those are the types that are permitted. And then if you want, a conditional use would be like a newer used car establishment, a transportation terminal, outdoor theaters, amusement parks. So those are the things that then he would have to come in and get a conditional use permit for.
yeah, got it.
Any further discussion by the committee?
Just some clarification. This was an area that the town has been working on remapping already. I mean, were they,
What do you mean by remapping?
well, I thought there was some comment that the maps weren't necessarily correct.
The comprehensive plan doesn't show anything for commercial there on the comprehensive plan, but that commercial, there's been commercial activity going on there for decades.
And it's been zone commercial.
And it's been zone commercial, so I don't know where, I guess we're maybe a little confused on why their comprehensive plan doesn't show that as commercial when it was zone commercial before the comprehensive plan was done.
Right, but so we know, the comprehensive plan is all generalities.
Correct.
And say, okay, we'd like this, so what that would tell me is if somebody else wanted to rezone to commercial, we'd talk to the town about amending their plan.
Yeah.
But in this case, because it was already commercial and his movement of commercial is to the east, towards where there is commercial in Danbury. You know, maybe at some point the town might go from that one back to the next commercial spot, you know, quarter-mile east with their map, but they didn't.
Yeah, and I mean, you have a campground a quarter mile down the road on the north side of 77, so I mean, it's.
There is, which doesn't require commercial, although.
Correct. That's
In today's world,
Yeah.
we go to our C district to rezone for a campground. So I think that's something the town said is fine with us. We should just maybe note on the record, the town should probably look at their map, future land use. Next time they get a kick at it, they don't need to change it now. But it's, you know, we should reflect what's actually going on. But I don't see any issue with this property being totally commercial versus part commercial at this point.
And then the only other question I have would be for Jason. Traditionally, you know, there's the violation of the structure appears to be bigger than was permitted. What would be the correction for that?
Well, it's been more than 10 years, so there's nothing we can do about it.
Oh.
Yeah.
Just documenting the size for the.
Yeah, it's documented, and we have aerial photo now that you can see the size of it, so. We know what it is now, but.
Any further discussion with the committee? Hearing none, I'd entertain a motion.
Motion to approve the rezone request map 2602 Hardy. Rezone from C1 and RR3 to all C1. And with the staff recommendation to follow all local, county, state, and federal requirements for this activity. And to send it on to the county board for their approval with our recommendation.
Well, second.
Motion by Supervisor Blomberg, seconded by Supervisor Szymanski. Any discussion further on the motion? Hearing none, roll call vote. Supervisor Tucker,
Yes.
Supervisor Miller,
Yes.
Supervisor Szymanski,
Yes.
Supervisor Blumberg,
Yes.
Supervisor Chuck Anderson,
Yes.
Supervisor Karen Aqua Anderson,
Yes.
Supervisor Conway, yes. Motion's carried to reference to recommend approval to the county board.
So like I mentioned with the last one, I'll go to the county board on your behalf. You don't have to be there, and then I'll send you a letter afterwards. I'm likely to be approved, so. Yep. I'm gonna pass around the two resolutions for you guys to sign while you're
Okay,
going on to the next one.
conditional use permit CUP 2519, Willow Lake Global Home Park LLC, which we had postponed a decision on that to this meeting because of seeking some clarity from corp counsel. And the applicant Andy, who is online, I believe, Andy Freeman. Are you there, Andy?
I am here, yes.
Okay, good. So. We have, you wanna expound any further on what you already talked about last time?
Do I want to?
Yeah. Anything to add to the previous discussion?
Well, I mean, no, I'm just waiting to hear your interpretation. Obviously, I mean, I strongly believe that zoning and land use can't determine boundaries and setbacks and all that, but zoning shouldn't be able to dictate how we monetize our property and what we charge for lot rent, whether we do or don't. So, I mean, that's my input, but you had that last time, so I don't have anything new.
Okay. Yeah. I'm gonna sign my name a couple times, so take 5 for just a second here. Okay, and since you're the applicant, Andy, I'm gonna do is open the public hearing, let other people speak out. No doubt, we'll call you back at some point, okay?
Okay.
So at this time, open the public hearing. Anybody else wishes to address the owner of the manufactured home, I think? You want to talk about it?
I'm just waiting to see what the lawyers. The county lawyer is gonna go through everything, just waiting to see if I'm gonna see.
Sure.
So I don't have anything to add from last time, just.
Well, as we discuss this further, we may bring you back into the discussion.
Could you say your name for the record too,
I'm
please?
Kim Sabraka, I'm the owner of the manufactured home.
Any further discussion? Don, are you here for the town board for anything?
Yes, sir.
As a county board supervisor, I'm sorry, town board supervisor, I'm not gonna limit you to 3 minutes, but keep in mind, this is gonna be kind of a running discussion, I think.
Sure. Thank you, Mr. Chair. Good morning. My name is Don Hamilton. I'm a Town of Oakland Board Supervisor and here today on behalf of the Town of Oakland. The town is opposed to removing condition 7 of CUP 2019. Many of you were here, some of you were not when CUP 2119 was originally applied for. And that application requested a 30-second commercial site. That request was denied by the Town Planning Commission and by this committee. And that denial was based on a referendum vote from the town that did not want expanded manufactured home parks. And additionally, because the request conflicted with and was inconsistent with the town comprehensive plan for density and development. However, through the collaborative efforts of the town, the county, and the applicant, the parcel owner, a 30-second site was approved, a non-rental site, with the condition 7 that this was to be the owner's residence. And the parcel owner at that time assured us that he would be a very present and engaged and attentive owner. That is what we were led to believe, and that it was strictly for the owner's residence because he owned all of the adjoining property. The town of Oakland, we believe we went above and beyond to help this parcel get CUP 2119 approved. The town has stated previously, and we would like to restate today, our willingness to support alternative solutions other than removing condition 7. Removing condition 7 would gut the pillar condition upon which CUP 2119 was approved. Removing condition 7 simply because the current parcel owner is aware one of the 32 sites is non-rental, not to be monetized, would greatly harm the integrity of the CUP process, and in the town's opinion, would do a great disservice to the hundreds and hundreds of Burnett County conditional use permit holders who currently comply with their conditional use permit and all of the conditions of record, regardless of whether they like them or not. Again, the town of Oakland, we had alternative solutions when CUP 2119 came up. We acquiesced to the parcel owner. We found a way to yes, and we are disappointed that condition 7 is being discussed to be removed. And again, we are open to alternative solutions, but we do not believe it is in the best interest of good government to remove a condition by relitigating it just because there's a new parcel owner and they don't like it. So I'll subject to your question. I'm finished.
I just want one question for clarity. Did the previous owner, Du Bois, offer that condition to the town? Is that how that
Correct.
came from you?
Correct.
Because the land use committee accepted the town's recommendation on this.
Correct. He came back to us when we discussed the inconsistency and the town referendum that was 83% opposed to expanding the park. He came back to us and said, you know, I'm a hunter. I bought this other land. I want to be here. I'll be attentive. I'm only going to use it as my residence.
My point is that the potential of surveying a separate lot for this part, manufactured home he placed there was discussed back at that time, correct?
Yes, sir. We suggested that at that time to carve out, if you're going to use it for the owner's residence to keep it clean, carve out that lot, get it surveyed, get it done, carve it. You own the land north of there, west of there, carve it out of the park. He said he was gonna do his own well, his own septic. It was gonna be an independent residence and not rental anyway. And his reply was, I own everything. Why do you want to make me spend all that money on surveying and all of this other unnecessary expense when I own it all already? And we bought it.
Okay, well, I just wanted to get clarification on that.
Correct. But yes, that was discussed.
Any
at
other
length.
members of the committee have any further questions? Okay,
Thank you.
anybody else to discuss? I think Nick Vivian is on the line.
Yes, thank you, Mr. Chairman.
Mark Crosby's coming up.
Okay.
Mark Krause, Wagner Surveying. We did all the original surveying for this CUP and all the locations and so forth out there. And the owner, Rick Du Bois, went through a lot of steps to take care of all this stuff. This was multiple parcels when the lots in the mobile home park was created. And as Jason, is on your list there, you can see there was probably 50 conditional use permits, applications and permits and so forth that were put on there. Part of this person, Mr. Du Bois, did not spend money doing this. We documented all of the campground, all the mobile home parks, the garages, documented to help aid the zoning office in getting these things created, also the town of Oakland, because this was all undocumented. It was very loosely done. It was done back in the 70s and 80s. And so these rules and recommendations were not in place that you have nowadays for your conditional use permit and your mobile home parks. And so a lot of money was spent and a lot of time was spent surveying and separating these lots. We showed the density developments. We showed the amount of lots on there. And as Mr. Hamilton said, that discussion was made. I don't remember it being as cut and dried and as locked in as what he says. I also know that the referendum was a recommendation vote. It was not a referendum vote for this. It was a question, do you want smaller lots, bigger lots type of thing? It wasn't a referendum that was brought to the township. So that vote, it was a recommendation, same as the planning commission is a planning recommendation. I see this as a form of ownership. If you deal with condominiums or anything else that has rental properties and so forth, ownership and lots can be sold. There are 31 other units out here right now. It would be wise to be in the same consistent pattern out here with this one unit instead of having a separate lot in the middle of that area. I understand the difference between the rental and that, but it still was permitted to have a residence there. The residence still there. The garage was laid out. The garage was applied for on the original permit. All these things were laid out. Everything is documented. We changed the lot lines to include a 14-acre parcel. We could have made it bigger if they wanted to. Mr. DuBois was an active hunter. We were limited when we could work out there because he was hunting when we were doing some of our survey work. And so I do know that his intent was to stay there. What happened since that time, I have not been involved with. But from what I know, that's where things were as far as what happened originally. So
A question for you, as long as you're up here, and it's hypothetical, but should we make have a determination that the thing to do is to create that separate lot now? And I was playing on the website, the county system, looks to me like a 30,000 square foot lot could be made around that unit. Which would then make it a legal separate parcel, would eliminate it from the manufactured home park. But we could probably do that using density development criteria and let it stay our R3. The town would have to recognize that it's 10-acre minimum parcel size wouldn't apply here. But I don't think they have an appeal or a variance provision, which they should have in the ordinance. So we could invalidate it from that reason. But that wouldn't be very hard to do, would it? Because you've got it all mapped right now.
yeah, and the question again is why?
I agree. It's a distinction without a difference, okay?
Exactly.
Right?
Mhm.
Exactly. But it does protect the integrity of the town and county's action, which is slightly, the only qualms I have at all is I don't want to see a bunch of other people coming in wanting to have theirs amended too, I don't know that it would. This is a really unique situation. But I'm just saying it could be done relatively simply if it was agreed upon that we would let it happen, right?
Yes. And it's like many of your conditional use permits, conditions are altered or modified as seen fit. I had one question for Jason. And I don't remember this because I wasn't part of the permitting or that process. Is he on his own septic and well?
Yeah.
Okay.
Yeah, it is.
And so, yeah,
Looking at the sanitary permit for that site, it runs down towards the cluster cells for the part of the campground, or sorry, mobile home park. But I think a line could be squeezed in there between them and come up with about 40,000 square feet.
and I know the area to the north was kind of their refuse or their debris pile and so forth, and that was put on his property or on the property that he kept for the hunting property. And the other thing, as far as density and so forth there, you do have the golf course on the east side completely, that's green space. You have his large tract that he combined all together that would be much more difficult now with the 10-acre minimums in Oakland to divide and so forth. And so there's a lot of density right here, but there's also a lot of green space around this property that was all part of contiguous with that same ownership at one time too. So it was.
All right, I was throwing it out as a hypothetical for maybe, that's probably the only realistic alternative is either that or remove the condition, to my mind.
Yeah, and in my mind, if they have that as part of the campground, if they ever do need to redo their septics and so forth, it would be better to have that land space in with the mobile home park than outside the mobile home park. So it would also allow because if otherwise we're going to reduce the mobile home park size.
True, but I
And
think,
so, yeah,
I think the mobile home park is already more than big enough to accommodate the units it has.
yeah, right. So
So that 30,000 square feet wouldn't matter much.
not too much.
So,
Okay, thank you.
thanks. Okay, now, Nick Vivian was about to speak. Go ahead, Nick.
Thank you, Mr. Chairman. I serve as the town attorney for the town of Oakland. I'm an attorney with the Eckberg Lammers Law Firm. And Don asked me to take a look at this. We've been looking at this since inception. And recognizing a couple of things as we move forward. As Don indicated, the existing CUP 21-19 was really a collaborative and cooperative effort between the town and the county and the landowner at the time. And really what it resulted in was a contract or an agreement as to how the fundamental aspects of that property would be utilized and how it would be memorialized and how it would be regulated. The applicant just indicated that it shouldn't be the role of zoning to determine how they monetize the property. And that's not the issue. That's really kind of a misstatement of what's going on here. Because when you go back to the CUP 21-19, it was really about, how do we put something in place from a town and a county perspective that makes sense, that reflects what the applicant wants to do, but that puts protections in place from the town's perspective, not to violate what the town was trying to do here in restricting or controlling the use of this property. I've read the opinion of your corporation counsel dated December 29th, and I disagree with it from the perspective that she indicates that there's no substantial evidence to deny this request. But as Mr. Chairman had suggested, really what's being asked is not that the whole application be reviewed, but just that this condition 7 be removed. And that the reality is, with a conditional use permit application, you have to look at the totality, and removing condition 7 would really be akin to approving the entire CUP without that condition. And there are reasons for that condition, and we know that there was a lot of work that went into approving that conditional use permit with that condition 7 included. So I reject her premise that we have to show, the town has to show, or somebody else has to show that there's substantial evidence to remove a condition. Rather, the committee would have to find that there is substantial evidence to move forward with the conditional use permit without that particular condition. And I haven't seen it, reviewing the record, reviewing the minutes of the last meeting and the tape and whatnot. The applicant simply wants to remove that condition so that he can make more money and monetize this property in a different way, which just that's not consistent with what the law has to say. It's not about health, safety, welfare. It's about a financial model and the operation of the park. So, we as a town would urge the committee to reject the request because there is no substantial evidence that would support or allow this conditional use permit to be approved without that condition 7, or to remove that condition 7. And at the same time, I think what you've heard from Don on behalf of the town is that the town is willing to work with the county and willing to work with the applicant in terms of density, in terms of, how we might look at this alternatively. We just think it's bad policy, and we don't think that there's evidence that supports removing a condition that somebody doesn't like. And we do think that the chairman's fears are valid, that if you grant this one, and I'm not a slippery slope guy, but if you grant this one, then you're going to have other folks that come in and say, well, we don't really like conditions in our previously granted conditional use permits, so you should approve the removal of those conditions. That's not good policy. It's not supported by the law. And to the extent there are alternatives, like carving off another lot, I think the town is more than willing to work with the county and with the applicant. But we don't see this process as a viable, legitimate, or legal way of going about addressing this particular concern. And so we appreciate the consideration of the committee, and we urge the committee to reject the request, but we're supportive of finding a way to deal with this in a more appropriate and consistent manner with the law. Thank you.
Is there anyone else online or here who wants to speak on this?
Am I allowed to speak a little bit more, or at least speak?
Pardon?
Andy wants.
Oh, sure, yeah, you're the applicant. You're not limited.
Yeah, so I want to, I mean, I think we need to be focusing on the present form here. There's just a lot of talk about revisiting the 2021 intent, and we're not relitigating the past here. It's about how condition 7 is written and how is it being interpreted today. And that's the whole thing. This stems from the ambiguity of how that CUP application, how it was condition 7 was written, that it must be owner's residence, which we've held steadfast the whole time that it is an owner's residence. This lot is no different than any other lot in the park. Kim owns her home and she pays lot rent and rents the home like every other one in the park. It's on the same parcel. All this talk about being on a different parcel, it's on the same parcel. There's many homes in mobile home parks that have their own well, septic, right? There's 1-to-1 systems. There's 2 homes to 1. So it's not even about that it has its own. This home, for all intents and purposes, is just another site in the park. And there's no other workaround other than removing this condition. I understand the town. I understand they feel tricked by the previous owner, but that's in the past. We're trying to deal with the present state of the CUP, and we only applied to have it changed and modified at the direction of the county. They say, hey, this is the process. You have the option to submit a CUP to application to modify a condition. That's what we did. We don't agree with it. We didn't want to jump straight to going litigious and trying to argue it in higher court or whatever. I don't know, whatever our lawyer would have advised us to do. We tried to play nice and go the route that was communicated to us, right? And at the end of the day, they think it's all about us just wanting to grab money for one lot. But we have a 70-year-old woman with her husband who's got stage 4 cancer. And this whole time that's been going on, she's been sitting here worried, sick. I don't know, the stress alone could kill her, from sitting here waiting to see if she's going to get thrown out of her house or not. That's the whole thing. We just want Kim and her husband to be able to live in the park like everyone else. They're not renters. It's not a rental unit. They're renting a home site. It's a completely different thing by the definition of rental property. If you do any kind of further analysis or research, there's totally different definitions when it comes to manufactured house law on what constitutes rental property. This is not a rental property. They're renting a site. And I don't want to, I just don't, this back and forth, this battle over when the real victim here is Kim and Paul. I mean, they're dealing with the stress, right? If I lose one lot of income, it's not about that, right? We have vacancies in parks. We have collection issues in other parks. This park, everyone pays the rent. We're doing fine here. It's not about this one lot and the income it generates. So that's being misconstrued here. It's about Kim and Paul being able to get their garage, right? And being able to get their garage and be able to live with definitive peace of mind that they can stay there long term and they're not one day going to be thrown out because they're lot 32. Everyone else is the same, but their lot happens to be lot 32 that wasn't allowed or where the town was tricked, and they get thrown out. And I still have never been told if this CUP is enforced and they're not allowed to deliver, what are we supposed to do? Where do Kim and Paul go now? They go, they have to sell their home. They have to move their home. I still have not heard an answer to that. So this is not about the park being greedy, one lot revenue that gives us $500. I mean, it's not big whoop. It's about Kim and Paul and having the peace of mind and be able to stay in the property that they live. These are not outsiders. Their mother the family member was the first resident of Wildwood Estates when it was built, I believe. I might be saying that wrong, but it's not, this is not a VRBO Airbnb situation where this has become rental property that's being rented out by outsiders. I mean, you have a very solid tenant that has a high pride of ownership who wants to spend thousands of dollars to build a garage and put money back into their property and beautify the community. So I just don't see the pushback. So that's all I have.
I'm speaking only for myself. I don't think we intend to have any adverse consequences on Kim and her husband, but we're just trying to figure out one of 2 ways to do it. If it was on a separate parcel, of course, the garage could be any size they wanted it to be. If it's within the manufactured home community, it's bound by the other conditions of the 24 square garage, which is okay with you. So that's all.
I don't own another parcel though. That's the thing. I don't have a parcel. There's no point for us to parcel out her lot. Then what does that do to I mean, that wouldn't make sense. I understand when Rick could shuffle around parcels, he owned a bunch of land, but we only own that one parcel. And for lenders and all that. I mean, it would open up a whole can of worms to start parceling out single sites in our home, and that's not how mobile home parks work. I mean, they're all always on the same parcel. There's sometimes two large parcels or whatever, but for the majority of the time, they're all one parcel, all the lots. They're all treated the same.
Okay, if there's nothing further to discuss, I will close the public hearing and open it to the committee.
Jason, what's this zoned right now?
RR3.
And before Cup, the old one, 2119, is that it? It was zoned RR3 back then as well,
Correct.
and it was 31 lots, but was this piece of property wasn't in the original 31?
21.
Well, he said, no, there's 31
Oh, Okay,
sites.
sorry.
Yep. Yeah, I don't remember what that parcel looked like
It was part of the, back 38.
because he did own a couple other parcels
To the north.
to the north. Yep.
So he carved out a piece and added it to the mobile home park.
No, I think what he did is I think the mobile home park actually included more land to the north in the past, and I think he pulled that north line down. I think he made the manufactured home parcel smaller.
Which included site 32.
Yes.
Yes.
Site 32 has always been a part of the park, Don?
But also, in 2022, they redid the line to contract the park on the west. That was also done to give more hunting land to the previous owner. So the park did contract, I believe, 14, it went from Jason 26 to 14. 2022, there was another cup after 21 where the park actually got smaller. And that was supported by the committee and the town to, again, prevent overdevelopment. That was supported.
But even then, there were 32 sites there.
Yes.
32, but Cup 21, one was non-rental. Yeah, correct.
So CUP 2119 happened first. That was to add the 32nd site with the condition that we're all discussing. And then in 2022, there was a CUP done that reduced the manufactured home park parcel from 26 acres to 14 acres. So then they
So
shrunk.
I guess I'm confused why we had to have a cup to add site 32 when it was already there.
It wasn't there.
They added after the park was.
So it was 31.
Piece of property?
No, it was only 31 units,
Right.
and then he got the CUP in 21 to add site 32 with the condition that we're
So the
discussing
county only
today.
approved 31 units.
Well,
Before-
initially 31, an additional one with that constriction or limitation on its use was added subsequently to the 31.
All the townspeople didn't want the park to expand, but they allowed this one site for the owner. But now he sold it.
Right.
Yeah, I think,
So then I guess that's where I'm kind of confused, is it didn't really expand.
Yeah, it went from 31 to 32.
That was there. That
No,
that
no,
property
they-
was there.
Property was there, but the site was not there.
So you're just saying you want to add one more rental site?
Yeah.
yeah, convert the private use site to a rental site.
And what's the town's big beef about doing that?
Cause then you take away number 7.
No, I'm asking Don, why, at that point in time, why did you not want to add another site?
Well, two reasons. One, it conflicted with our vote. There was a question put out as a vote when we redid our comprehensive land use plan in 2018, 2019. That was a significant issue that the town had. We lead the county in the number of these parks and campgrounds, and there was some pushback about that from Mr. Krause and other people that said, well, why was that in the comprehensive plan? Well, that was the collaborative input of the public on that plan. So at the time, I was not on the town board, they put it to the community. They asked the question, do you want expanded manufactured home parks? And that's where the answer came back, 83% on that election question. They do not want any expanded. So that was the one issue, was the vote. The second issue was it's also a pillar in our comprehensive strategic land use plan that the town of Oakland, who leads the county in the number of these developments, that we are at our max capacity. We do not want any more, nor do we want to expand the current ones. Those were the two reasons why the town denied it.
Go ahead.
It's not like they were asking to expand it. They used that piece of property. He had dumpsters on it. There's no backyard, absolutely none. There's a deck on the house, drops down. The garage would go right here and that's all septic. So they won't build in that little piece of property over there. That's all septic. You can't build over septic. And over here, that's a landfill and it goes like this. And so they're not asking to expand the park. They just put my house there and all I'm asking for is a dang garage.
Right.
Like everybody else in the park,
Oh,
all 31 other people.
no issue with that. I don't think you have to worry about that part.
You,
But I'm just trying to say, that's not what the debate is really about. It's more or less the how. So we're close to public hearing, so we're not gonna get off into that other than a specific question. If somebody,
Some clarification on the maps and what was done up there,
Sure.
as far as the drawings. I don't know what you have on your drawings and so forth. It's a little bit hard to see on this one because it's such a big piece of property on a small lot. But this is where the mobile home park is, this lot one down here. This diagonal line is the road that goes to the back property. The house for the one we're talking about is right about where my thumb is, on the very top corner.
We have that on the
Right.
packet, but it's
This parcel here was the one that was part of the mobile home park
originally, yeah.
originally. And this was included with part of that. There's a big ravine and where they have their debris pile right here. This drops back off to Buffalo Lake here. So this property was deemed not to be developed or whatever, and was included with the rest of the property that Mr. DuBois bought here, which was 34 acres. And that was part of the reason to divide that off, so the 34 acres could not be developed into more mobile home park. And so by having it separate, also protected the town and the county from that question being asked. In my, that's part of the reason we separated into two ownerships was, this is a mobile home park from here south. This is wildland to the north. So that's, if there's you have any questions more on that, Randy, that's kind of where the numbers are there.
Just so everybody's got it straight, right?
Yeah, so before you had a density of, you had 31 units on 26 acres. Now you have 32 units on 14 acres. So your density has gone up with the number of units because you have less acreage.
But it still satisfies our criteria
Correct.
for manufactured home communities.
Right.
Which are a separate thing. Go ahead.
I got a question. Okay, so if you taken that parcel and you lot it off as its own identity, how do they get to their property? Cause now they're gonna need an easement to cross the trailer park.
They would, yeah, they would.
And if they don't grant access,
Well, it would have to happen if, we wouldn't allow a lot to be created without the easement. So,
but it gets to be opening up another can of worms, so.
it happens all the time, but I don't disagree. I mean, I think that boils down to, there's only two alternatives, really. One is to provide a separate lot for that, for her place, and one is to just remove the condition. There isn't any other options, to my mind.
My struggle with this is, unfortunately, the new owner of the park and the new owner of that parcel were somehow unaware of this condition, didn't look for it. By erasing it, I think, what's the point of us having conditions and we're asking the town for their input? Yet at the same time, the general effect on the county and the land, I don't see. I mean, the big danger to me is the value of any conditional use we put on anything. But the effect that it's gonna have at this point is minimal. I mean, because it doesn't really change the use.
Just clarity, right?
Yeah.
If Mr. McGraw still owned it, it would be a no-brainer. We would make him survey a lot, right? Because he's the owner that agreed to all this, and he's the one who then circumvented it to add it to the park without it being approved, right? But we can't make him do it, you know, so we wind up with a victimized, and more importantly, to my mind, the new owners of the manufactured home harmed, right? So, you know, we don't wanna harm any of them. My point about creating a parcel is it wouldn't be very expensive to do. It's kind of contrary to what the Andy would like, I'm sure. It could be done. You know, but, and it would be, it would not affect, it would be a rented lot rather than a rented site, you know? As I said, it's a distinction without a difference, but it doesn't compromise the condition. But that's, you know, it doesn't, whether it's worth to be around, I'm, you know, ambivalent myself.
I guess my question is, what's put before us is to either vote to remove condition 7 or vote to leave it there. I mean, can we really put stipulations on this is what you're going to do? That would be a separate thing that they'd come forward with.
Good question, if we could do that, but I think we could say that we would the 30,000 square foot lot to create that separate parcel if we denied this. That would be the way I would couch it. Go ahead, Chuck.
Just a question. If the owner now of the mobile home park had done his due diligence and found this piece, would he have had to have the burden of resurveying it, or would the old owner have to have the burden of resurveying it?
It would depend on how they would the offer of purchase, but I think if he wanted it to be a rentable unit within the mobile home park, then it would have been an obligation of the seller to come back to the committee for that, not him holding the bag after the fact, right?
So that could still be done at this point.
I don't think so, because
They couldn't resurvey it and make it a separate lot,
oh, yeah, we could do that, but
and then it wouldn't.
But the point would be, if the original one was the one who would offer that condition was the one to remove it, it would be a lot easier decision to my mind, because he's the guy who made the agreement in the first place. But he sold the manufactured home to them, and then sold the park to Andy, and without them being aware that this was going to come back and bite people at some point. And that's what I think. My version of what I think happened, right?
But I mean, something can be worked out is what I'm trying to say, because I'm definitely not in favor of redoing a cup, because I think it's gonna open a can of worms for everybody else that has got one in the past and says, oh, now I want to do it this way instead of the way I wanted to do it to begin with. So I'm definitely not in favor of taking that commitment out.
Right, you have any thoughts on this you want to share?
None at this time, thank you.
Okay.
One clarifying thing for me, now that Corp Counsel is in the room. I may have misread your opinion, but I thought what I read in there is that there was some question about whether or not we could even enforce item number 7, and that we have the authority to say you can't rent this property and it has to be an owner's residence.
I think what I was trying to say is with regard to the proposed the discussion last time, where there would be sort of a side agreement where Mr. Freeman would not charge the lot rent portion of the lot rent. I believe that is what I was referring to. Not so much enforcing the particular condition, but changing the condition to affect that private contractual relationship in that manner. And I apologize if I wasn't as clear in my language.
He's, okay.
Mr. Chair?
Yes. Who's talking? Oh, okay, go ahead, sorry. I wasn't looking.
Thank you so much. It's been an interesting debate on this. And I guess if I had been in the land use committee back when this came up, let's just say we have it in front of us now, I would not be in favor of having a condition on that cup to state that the owner has to live on that lot. And they're not renting out the building. And whether a person lives there owning it or lives there because they're leasing the space or renting the space to use the septic and the water, we still have the same impact on society, on land and water use and all those things. It's unfortunate this came to this, but I'm in favor of removing condition number 7.
Okay. Lee, do you have anything to add further?
I'm in favor of removing 7.
Yeah, I do think it was unique enough circumstances where we have a fallback to say if somebody else wanted to do it, you haven't been through this particular weird chain of events. You know, I get that too. I think there's a reasonable chance the town could appeal it if we approve it. And then that would move it up the food chain to a higher power than us to make the call. But so I think the two options, I don't think we deny it unless we provide a path to get without harming the owners, you know. Getting it in the court would cost money too. So, but that's my thoughts on it. I still prefer to maintain the integrity of the conditional use permit process, you know, all else being equal, but in this particular case, it's a pretty distinction without a difference, as I've called it, right? It's not gonna remove the mobile home, not gonna do anything about the site, it just would change its ownership situation from in a park to an independent lot owned by the owner of the park. That would be what would happen if we did that. But you know, we gotta move this along today. I don't want to delay it anymore.
I agree. I mean, for me, there's a difference between if the person that applied for this cup was sitting here asking us to change it, that's different than the situation we have today. And as someone says, things change, and when situations change and conditions change, we should take that into consideration.
Well, the other side of this is that both the county and town in this way were gullible and naive about putting that condition in, frankly, because as Stephanie's kind of clarified, it needs to be measurable, it needs to be enforceable, it needs to, you know, we gotta be careful about doing that type of condition. That's a feel-good condition, but we're not looking at a path. If that condition would have said at the time of ownership, this CUP expires, which we can do under Act 67, but in 2019, we weren't thinking like that yet. Well, that's what we should probably do, on something that's a personal license. You know, one person's unique use type of thing. We should probably, it shouldn't be a condition which should expire, right? But we didn't know that then yet, really. That was prior to Act 67, 2017-67. These things ran with the land, they did not run with the owner. And we were not to sunset them at sale. We could review them, you know, but that changed. That was provided for now in Act 67. So it does kind of change the way we should look at things. So I think what we're kind of seeing here is a good intentions going to arrive on the part of the town and county, but consequences we didn't anticipate either. Go ahead.
I guess just a comment. I don't see any reason not to remove it other than hurting the integrity of the CUP process. But it will make me a lot more leery going forward about trusting or believing. I mean, because it's attached to the property. and, you know, just willy-nilly changing and getting rid of things, you know,
I don't
is,
think this is willy-nilly.
well, for them, it's
Not for them, it's not.
I know, but for us, we're just disregard, for them, it's not, and that's what I said. But from the town's perspective, it's kind of like they agreed to something and now it's going to be erased. You know, even though technically it should probably stand. It's just, I think it decreases the trust in, you know, when someone promises to do something, but if they're not gonna be around to follow through on it, then, you know, are we hesitant to allow things to happen because they won't be around to deal with it?
I would just like to point out, according to the Corp Council's opinion, legally, there's not a justification to deny the request to modify conditional use permit removing condition 7 that has been presented either at the public hearing or through written submissions.
And
So we don't have legal justification to even deny this.
well, I thought her clarification said when we were going to change the condition to,
That's paragraph.
okay.
There's absent substantial evidence that denying the application will have any effect on health, general welfare, or safety, economic prosperity.
That's where we get into the debate between the two attorneys. Where one under Act 67, that's absolutely true. And then if it's not Act 67, it's not, but we're not gonna debate that.
No.
You're not a court.
But they still have options if we deny, if we keep item 7 in, they still have options where they can move ahead.
The only option would be, in my opinion only, the only option would be that to separate a parcel. Which could be done without any further actions by us.
That just needs a surveyor.
Yeah, it needs a surveyor, but and Mark, we talked about it a little bit, he's got it all mapped. It could be done,
And then it'd be set forever and we still have the conditions.
yes, that would be true.
So then what,
What would happen to you with that?
who would pay for the survey and how would that affect me?
Well, I'm gonna say that the survey would probably need to be paid for by the owner of the property, which would be Andy. And then you would be renting a lot from Andy instead of a mobile home park site from Andy. It would, the contract you would have would be the same, or ultimately, you maybe work out a deal where you would purchase a lot from Andy and then own it outright. Either way, but that would be the difference, you know, there's no reason you couldn't lease the lot with the same kind of arrangement and fees as you pay now to the manufactured home community. But that would have to be done, we can't, as Stephanie's opinion points out, we can't tell him how to do it. Mark? Go ahead.
Another question, if we're going with Chuck's route or whatever, or we're gonna work this through, what's from that? We'd have to have a guarantee from the town of Oakland that they can prove that, because they don't allow any minimums anymore either, so.
I think-
We technically can't create that in the town of Oakland right now based on their new rules.
I think Oakland would agree, and I think that's partly because their subdivision ordinance fails to provide the variance or waiver opportunity that it ought to. It views the world as a checkerboard, and you and I both know the world is not a checkerboard, right?
And the town has had a couple of exceptions already, so the town, the town supports. If Mr. Freeman wants to pull a land use permit for a 24x24 garage, the town is not opposed to the garage, that is a non-issue with the town. But the town will support and has demonstrated support for unique situations and exceptions, primarily because we failed to include a variance process in our original ordinance. So we support that process.
Okay, so on the record, the town would have no opposition to creating that parcel.
No, we have demonstrated that in the past. We would look forward and support those discussions moving forward.
My comment would be though, they're creating parcels that doesn't have anything to do with zoning or anything else, so it wouldn't have to come before us or this, so that is a decision that they would be able to make, okay.
Right, it would just be, a certified survey map could probably be done in a month. Right, Mark? Okay,
Mr. Chair, could we put this to a vote? Just to see kind of where we are here?
I'm sorry, I didn't hear the
He
question.
wants to put it to a vote.
Oh, okay. And with no further discussion, I entertain a motion.
Well, the motion is already to strike item 7, right? Isn't that the?
There hasn't been a motion been made yet.
No,
No.
I'll make a motion that we do not strike item 7.
Okay, but would you add to that motion that you would, that the committee, it's going on the record that the committee, the land use department in the town of Oakland would provide for the creation of a minimum size lot under the density development provisions of the ordinance to allow this parcel to be severed from the manufactured home community and allow the occupant to continue to occupy it, get a permit for the garage once the CSM is completed. Right?
Yep. You said that more eloquently than I could.
It's just putting words in your mouth.
Thank you.
Did you get that? Motion?
It's basically motion to deny removing condition number 7, but then allow a lot to be created for this site, separating it from the manufactured home park using density development.
Which would allow the manufactured home to remain and allow the occupant to continue to occupy it, subject,
So we can't have discussion until someone seconds it, right?
yes.
Okay.
Did you second it?
Nope, I didn't, but if someone does, I'll.
You just created another mobile home park.
No, just a lot.
It's a mobile home park with one lot. Which goes against your stuff right there. Doesn't make any sense logically. No, you could still say that item number 7 is.
I'll second it for discussion, okay? It doesn't do it because you can have a manufactured home on any parcel with a permit. It's no different than a stick-built home.
I have one.
I agree, but it's not what the town wants according to the vote.
And I guess my point would be, is it beyond us? I mean, unless you're just kind of stating we'd probably support it. I think kind of dictating that goes beyond. I mean, I think our role is to approve or deny it and give an indication that we're probably supportive.
This was proven just beside the end of the mobile home park. If it was going out in the middle of the golf course and creating a lot, that would be not an addition. It would just be a lot. That's the same thing that we're trying to do here. It's not an addition to the mobile home park. It's a separate lot that they built their house on.
It just happens to be, but still adjacent to the mobile home park.
Happens to be adjacent.
That's what it would mean. It's not even in the middle of the mobile home park. And as far as the resolution and I'm adding those words to this is that I don't want us to just deny it and say, don't fight about it when yourselves about it. I think that's irresponsible by us. I think we're saying this is the path we see as an alternative to denying, we're approving this request to remove the condition. And I'm not overjoyed about either option, but I think it's the way that we correct the error of the past and do what should have initially been done anyway, which was create a separate parcel for that lot, for that site. That's what the boys should have done.
We meet Thursday, so time is not an issue.
Okay, so I second the motion for further discussion. So any further discussion?
I have a comment regarding separating that out to a separate lot. There's already septic and water there. We are creating a lot more expense for somebody. And in the end, there's still gonna be a family living there, whether they're an owner or an occupant and leasing the site. I just feel like we're expecting people to jump through hoops that don't need to be there.
There is a septic and well already there.
Yeah.
Yeah.
You know that. And as I said earlier, it's a distinction without a difference. I agree, but it maintains the process of the conditional use permit that I think is important to do too.
Can I ask something about the whole reason we were here today is because I filed an application to amend the cup at the instructions of the county, or I think Jason, and had talked with county council, and that's why we're here today. And so a cup as designed is able to be modified, and it has to be, a vote has to be taken on it, right? It's not, you can't, anyone can apply at any time to modify a cup. So I understand you're not wanting to set a precedent, but it's not like the cup is just immediately modified. I mean, this has been, I don't want to say a headache, but it's been a lot of steps, a lot of stress for a lot of parties. So it's not your cups that you've approved in the past are not all of a sudden going to be an influx of people like, well, I don't like this, I'm going to change this. I would say it's not an easy process. And it still has to be voted on. And the reason we're even here today is because the cup is clearly, to any higher level board of review that this has to possibly go to, if it ever has to go to that, is going to interpret that cup as ambiguous and vague. And that's the whole reason that we're having this discussion, because the cup wasn't a definitive line in the sand interpretation that could be easily understood, where I would say, hey, this is clear, man. It says Rick DuBois, mobile home park owner, must live in this house for this amount of time. It cannot, new person does not count as an, it doesn't say Rick DuBois' name, it doesn't say mobile home park owner. It's clearly, that's the whole reason we're here, is because it's very, very vague. So if you have a crystal clear cup condition, how can someone who doesn't like it have it overturned? Because they know what they've agreed to. It says, so, it'd be clearly defined. They go to vote or have a, apply, and it gets shut down. If there's no basis or no grounds to have it to modify. This one is just clearly, there's just bad blood between Rick DuBois and who's not a bad I don't think is a bad person. I just think it was a misunderstanding in the beginning stages. It's gotten to this point, and now it's to the point where, there's a whole bunch of other back parts of this. If you want me to try to rezone the property, I have a lender, we have a survey, we have title commit, we have all this stuff that just can't all of a sudden magically be changed. And you want me to go jump through hoops, I'm not going to do it another parcel. So if that's not even an option, because that's just because this one condition doesn't want to come off because you don't want to set a precedent, which I understand and respect, but there's just a whole nother, I mean, we might have 5 or 6 more of these meetings down the road once we start asking to rezone the property. And then I got to go back to my lender, and I got to go do, I don't even know what other ramifications there are for this, because I've never been a part of something like this. I've never seen an interpretation like this, where one lot that's already on the property is now all of a sudden we put a different box around it on paper, mind you. This is just a paper boundary essentially. And now it's all of a sudden, now everything works. So that doesn't make sense. If it was as easy as just drawing a box around it, I maybe would do that, but I know there's a lot more steps involved than simply just saying, okay, it's its own lot or its own parcel. So at the end of the day, I don't think this is going to set a precedent that any cup that people aren't happy with can just be amended, because this is not it's a costly, time consuming process. At the end of the day, it still gets voted on, and it's not just something that can be overturned overnight. I guess that's what I'm trying to say. So I don't think it's going to open the floodgates to cup modifications, is what I'm trying to say. Thanks.
Mr. Chair, I'll go on to say that I've learned a lot about our housing crisis in the state. And a lot of what we're dealing with here today contributes to that problem. Government doesn't know how to get out of the way. And really, I think it's been stated already, but our agenda action item is to either remove the condition 7 or not. And I'd like to see us make a decision to, I'd be happy to make a motion to remove condition 7.
You gotta vote on your motion first.
Yeah. We got this one on the floor. So,
so the effect of the motion on the floor is to leave it stand, so a no vote does just stop it? Or, I mean.
Yeah, I think about that for a second.
The cup.
The motion was to deny not to deny the existing cup, but to deny the request to modify.
Right, So then that effect is what? Then we walk away from this meeting with no change.
Right.
Okay.
Right.
Just,
So there would be no yes or no. And we still didn't get anywhere. Is that what you're saying?
Well, what we're saying basically is if we vote to deny the modification to the cup, then nothing has changed, but we've described a way to solve the problem. If this motion fails, then we would discuss further, probably a motion to approve it. You know,
can you just keep putting different motions on the floor? I don't know how that works.
yeah,
Well, you can put a motion and you vote on it, then you can make another motion.
Yeah, put on this one first.
yeah. So, and I had a little trouble hearing, what was the motion Duke was talking about making?
Well, he said, I think he would make a motion to remove
Yeah, he did.
condition number 7. He'd be willing to do that. But I don't think he was making the motion because there's a motion on the floor
Okay.
now.
You're right, there's a motion on the floor, and I don't think it's gotten a second, has it? I didn't hear it.
Yes.
It did.
Yes, it did. Craig seconded it.
Yes, yes, I did. I wanted it to get discussed further because it's,
So if we were to vote to deny this one, then a motion could be thrown out to approve the motion or to approve the conditional use permit as was presented to us in the first place.
right, that would be the scenario. So the motion, on the floor,
Vote means we leave it in, a vote no means no.
yeah, correct. The vote in favor
Motion's down.
is to deny, and a vote not in favor is to not approve the motion.
No would be to,
No is no and yes is yes.
Yes means that we leave it as is.
The trigger is, it's an affirmative motion to deny. That's the way.
If I could, Mr. Chair, you're a little more muffled than what Jason is. Jason sounds great. Could I ask Jason to reiterate what the motion is so I don't screw this up?
Yeah, so the motion essentially was to deny modifying or deny removing condition number 7. But then with the caveat that a new lot would be created to chop off that one site to be its own separate parcel essentially.
Which would then remove it from the
Yes,
regulation.
then it's not part of the mobile home park. Yep.
Be no different than any other lot.
Yep.
I don't think we
It
can
could
make
be a lot anywhere in the.
to do that. We can make a motion that's probably what.
That's what we're seeking.
Okay.
We're just advising
Okay.
in that case.
Yeah.
We can't compel it, no. So. Any further discussion, I'll call for a vote on this motion. Supervisor Tucker,
No.
Supervisor Moyer,
No.
Supervisor Szymanski,
No.
Supervisor Blomberg,
no,
Supervisor Chuck Anderson,
Yes.
Supervisor Karen Lockley Anderson,
No,
Supervisor Conroy, yes. Motion fails. 5-2. So now I will entertain a motion to make a decision.
I'll make a motion to approve cup 2519.
Motion by Supervisor Szymanski to approve the removal of the condition.
would that include the conditions as specified by?
All we're doing is voting on number 7.
Right, it's only condition 7 being removed, all the other conditions pertaining to the manufactured housing would remain in effect.
Great, and I'll second that.
Okay, seconded by Supervisor Moyer. Is there any further discussion?
What about the staff items?
I mean, those are part of the prior CUPs anyhow, so if you don't state them, they don't go away.
No,
Okay,
all, just for the record, all the previous conditions,
Still apply.
staff recommendations still apply.
and that's essentially what is being said on point 1 there and point 2.
Okay, we're good? Are we good?
Sure.
Okay. Roll call vote. Supervisor Tucker,
Yes.
Supervisor Moyer,
Yes.
Supervisor Szymanski,
Yes.
Supervisor Blumberg,
Yes.
Supervisor Chuck Henderson,
No.
Supervisor Karen Blackway Anderson,
Yes.
Supervisor Conroy. Yes, I'm supporting the committee. So we're going to finally with this one, but let us take this into account every time we look at a conditional use from now on, that we don't inadvertently paint ourselves into a corner with a condition. Okay?
So basically what happened is they removed condition number 7, so now we can issue you a land use permit for a 24 by 24 garage. Or you could build it pending unless someone appeals that decision.
Just a point of order, Mr. Chair, the parcel owner is the person that should pull the land use permit, correct? Not, she doesn't own the land.
Correct.
So he has to pull the permit.
Well, he signs it. That's typically
That's
how.
why he applied for the CUP, because he was told that
But it's not.
he had to do it.
Right.
So we're good.
Yeah.
Just want to clarify.
Fine.
Clarifying, that's correct.
Yep.
She acts kind of as an agent for the owner, but he has to
He
agree
has
to
to
it.
sign the form. Yep.
So. Okay. Moving on, and we're done with this one, right? And the town's still might appeal, folks, keep in mind.
Wow.
Yeah, so that decision can be appealed though. There's an appeal window, so if like the town of Oakland doesn't like that decision, they can appeal it to circuit court, so.
So then,
I'm just letting you know that, I mean, this is a vote today that happened, but there's always
appeal it, so I know.
30 days, 30 days after the decision document is written.
Thank you.
Yeah, you kind of got caught in the crossfire, but it's a complicated issue. It should have never happened, really. You know, without everybody being in the loop right from the beginning. And then they could have got fixed right away.
I agree.
So
Thank you,
we're on
everyone.
to-
Thank you.
Hey, Jay.
Thank you.
On to land services.
Thank you, Andy, for being here.
Okay.
You ready for
Yep.
my exciting part of the meeting? So the reports are in there. Let's see what staff has been working on, budget report again. There's nothing in there out of the ordinary. Revenue, we're obviously fine on. This report was ran at 11 a.m. so it wasn't quite the end of the fiscal year. So we'll have, next month's report will be, final through the end of the fiscal year numbers, but
Yeah, we got a few more houses than even last time.
yep.
I was surprised about that.
Yeah. Yeah, so the permits there, 767 land use, 134 of those are dwellings. Last year was 103 dwellings. Yeah, stuff's still moving. People are still building and yeah, don't really see anything out of the ordinary.
Regarding the corner maintenance records, Pine County did 3 of the 4.
Well, those were corners that we already had corner sheets on. They did, they were on the state line up there, up in Blaine, and they did sheets on the corners as well.
So like an update.
Yeah, they wanted one with their surveyor doing the work and in their records essentially. With their own coordinates, because they're, we're each on our own coordinate system.
I suppose.
So he got his coordinates.
Is there much difference in the values of the coordinates?
Well, I think Minnesota is state plane coordinates and Burnett County is county coordinates, so those are completely different.
All right.
But they can all be
I thought when we
tied
did
back
I
now.
thought when we did the harm, it was all into a state project.
That was a Wisconsin state project, but we use the Burnett County coordinate system.
Okay.
Wisconsin is unique. We have 72 county systems. I think Minnesota runs 3 state plane systems is how they get their coordinates.
And I wasn't working in it anymore then, but I was running around putting up points and
Yeah.
working on Harn with Rod Ripley, and so
Yeah.
I just kind of assumed that was a state system.
Yeah.
And they oddly started it in the northwest corner,
Yeah.
which almost never happens, right? They start at Madison and then run out of money before they get to us.
What are theirs, hours?
Yeah, the monument location, they didn't modify it or change it or anything. It's just their coordinate system is a different coordinate system than ours. So,
And it's 2 sets of values.
yeah, 2 sets of values, but it can all be related back to one when through some conversion programs.
You're looking west, it's Minnesota, and you're looking east, it's Wisconsin, right? And that's a fascinating strip of land, because that state line boundary north and south from the St. Croix. The original survey was mileposts and half-mile posts. Then when they subdivided the sections and ran up against them, set some additional monuments for the corners, section corners and whatnot, so they're like every quarter mile is a corner,
Yep.
practically.
Yep.
All the way from the St. Louis River back down to the St. Croix. You'd have a hard time getting lost.
Yeah, you should not get lost on that line. Yeah. So otherwise, yeah, nothing really exciting. Right now, we should the aerial photos, the 2025 aerial photos, the hard drive is being sent to us today. Just got an email about it, so then hopefully we'll have those on the website here in a couple weeks. Yeah.
Future agenda items.
What's with the L on land?
Apparently that report did not like the number of characters. So it must be bumping. It must be cutting off the left hand portion of the L on the budget report.
Oh.
Yes, because I got quite a long name there for that report, so. Yeah, so it kind of, I think,
Yeah.
it's cutting off the left hand side of the L.
It's consistent anyway.
Yes. That's a New World issue.
So, and we have, our staff is all credentialed
Yep,
and we kept them
yep.
for a couple of years. Things are looking up.
Be nice to have some consistency for a while and not have to train people.
Yeah, well,
Yeah.
right. You know, and then the longer they're here, the more independently they can operate too.
Correct. Yeah.
So that's a good thing. Next meeting date will be February 3rd. No, we didn't talk about future agenda items. I don't think we have.
I keep putting on there that I gotta get the floodplain ordinance to you guys one of these months. So maybe I'll get to it next month. I don't know.
This is tentatively a good time to do it since we may have a light agenda.
Correct.
And hopefully what got done, it needs as much head scratching and debate as this one did.
And I have a thought on something I'd like to discuss in the future, probably not the next meeting, but when you look at all the conditional uses between Board of Adjustment and everything that we create, we're kind of creating a monster. And then I think maybe getting some input from Stephanie on how we create those so that we're not unintentionally creating conditions that aren't enforceable or that don't quite follow the law. And if there's some standard ones, I think we can just fine tune and maybe, yeah, fine tune what we do with conditional uses. So at some future date, I'd like to see.
I think we're all pretty good. This one was a weird one. So most of
Other permits, I've seen it, septic here. Yeah, it must be rough. So I think there is value in having to work.
Even though it seems like 100 years ago, 2019 was only about really maybe in 18 months at most from Act 67 actually coming crawling out from under the rock that it did, so to speak. And we were really pretty oblivious to some of those consequences to it, which hadn't yet been challenged on, you know. And we learned the hard way, is that we gotta watch what we say and what we do and how we present those things. So.
It's a learning curve, right, for all of us.
Well,
Yeah.
in a lot of ways, there really hasn't been any judicial guidance on some of the nuances about 67 even yet, that what it says, but like I raised the argument in the debate many years ago about that when we're talking about a new project, new construction, it's speculative on both sides as to what is going to happen. Will the traffic increase or won't it? Will it be safe or won't it? All of those sort of things would require a formal study maybe to have facts and, we're reluctant to order this kind of stuff. Anyway.
And I think you've answered this before, but, how easy is it for people to find, like if they're purchasing a property, how easy is it for them to find if there's a conditional use attached?
Well, so if you go on our GIS website, you click on the parcel and then you click permits, not report. Report brings you to the tax system. Click the word permits and it lists all the permits that are tied to that parcel. So then you would scroll through and, look for CUPs, rezones, variances.
In today's, I hadn't done it before because I had assumed that was in the cluster system, that parcel. And then when I realized that it had its own system, I was able to go on in the website, find the inspection reports and sanitary permits of the configuration of the system serving that parcel, find the more recent cluster cells for the units to the south, and pretty much determine that they didn't overlap each other. That enough to have a pretty good idea it was theoretically possible to create a lot, even though it was a distinction without a difference, as I keep saying. Wouldn't have mattered.
Yeah, there's a lot of information out there.
Right, but you need to know what you're looking at.
Correct.
Still,
Yes.
but the point is, it's there if you know how to look. And then, as an aside, the town of Jackson adopt a fire department's ordinance to inspect driveways for compliance, for access and whatnot. And I'm gonna go teach our fire chief how to use Beacon. Because he can do a lot of that. Rather than leaving the office, especially with the 25 photos coming up. And you can tell how far off the road the improvements are, whether they are subject to the turnarounds and whatnot. It'll be real, something we couldn't have done before we had that detail.
Yeah, I mean, we're kind of spoiled nowadays with the amount of information we have at our fingertips that even 10, 15 years ago when you guys were in zoning, that we didn't have.
We looked at a photo that was black and white and green, you can kind of tell a wetland from upland, but that's about it,
Yeah, what a great benefit for us and especially for the public, who years ago wouldn't be able to get all of this research.
Yeah. When I was going around getting my signatures on my papers, I was talking to a woman on Bonner Lake by me, who's a realtor. And she was, Jason, you remember that guy questioning where did my land go on that pie-shaped piece on the north end of Birch Island? She was a realtor who sold it.
Okay.
And I told her, you need sometime I will come over and teach you how to look on the website and how to measure stuff. Because she didn't understand what happened. It was supposedly a 5-acre parcel and it was really 3. He said, but the value of that parcel was based on 100 feet of frontage on Birch Island, not on some blue sky.
Yeah.
The lines diverged out by the Bonner or Kilgare Road. And if you took about 50 feet off across the whole back, you found about 1.5 acres. And, I explained that to her, but yeah, you need, sometime when you have time, I'll show you how to do this stuff.
I think all the local realtors are pretty good about using this. I think it's more of the maybe ones that aren't
She's new to it.
new and or aren't really active, like maybe they're a realtor out of the cities and they're listing or selling something for a
Semi-retired
something,
people
yeah.
dabbling, but the point is that could easily be explained using the information we have, right? And why it was like that, it was an ancient deed, it wasn't ever a surveyed parcel.
It's fantastic for snowmobile clubs, I can tell you that. We know all of our private property, you just follow the trail and copy it off the thing, and I got my work done in half hour. It was awesome.
So, anyway. Enough, I guess, motion to adjourn,
I make a motion to adjourn. Second.
motion by, motion made, seconded, all in favor, aye. I forgot about that, I was, yeah, we haven't adjourned yet.
We're slipping and sliding now.
Yeah, everybody.